Okay, here we are in part two, structure and process in California. All right. First, we're going to do more statistics, and then we're going to talk about the structure, and then we're going to talk about the process. Okay, so 2023 is the last year for solid data, as we said in part one. Uh, Child fatalities is used as a proxy for a lot of different things in child welfare, but it is often used as a proxy for true levels of maltreatment. So if the rate of child fatalities in a particular group is much, much, much higher than their representation in the population of children in foster care, you know that it's being underreported, right? So child fatalities as a number on its own is not that useful, right? Because it's a small number in relative terms, and it's not particularly accurate. um, but it does serve as a proxy for a lot of things. Okay, so California's rate of child fatality is about 2/3 of the national rate, but mm, again, this number is tricky in just to start with, but it's particularly tricky because what we are defining as a fatality attributed to maltreatment. Uh, I have some thoughts on this. I'm pretty sure that every state does this differently. So, I have personally been involved in cases where there were child fatalities, and it absolutely was due to maltreatment, and it was not attributed to that on the death certificate. Um, for one reason or another. And not to be cynical, but when a death is attributed to child maltreatment, that triggers a lot of things in the child welfare agency, and I think a lot of times the motivation is to avoid that. So this is not a number that I'm super excited about in terms of accuracy, but there it is. Okay, so nationally, 58% of reports meet criteria for an investigation. So that means if you have 100 calls to the hotline for reporting, 58 of those are going to be investigated. Well, okay, what about the rest of them? What about the other 42? So um, there are states where um, every call is investigated, regardless of what the allegation is. You could allege that the child's hair isn't brushed, right? And they'll investigate that. That is not the case in most places, but I have a feeling that those states do inflate these numbers a little bit. But in any case, nationally, for every 100 referrals, for every 100 calls, 58% of them meet criteria for investigation. In California, this is 50%. Um, in California, if if the allegation in the call were true and it does not constitute child abuse or neglect, so maltreatment, if it were true, it's not going to be investigated. What does that mean? So if you call and you say this child is not going to school, well, you will not find that in the Welfare and Institution Code, Section 300, which is child welfare. You're not going to find that there. It's a different law. Truancy is a different law, different court, different everything. So that's not going to get investigated because if it was true, it still doesn't fall under child welfare. It's not going to happen. However, if you call and you say, I saw this child with bruises, and I think that they're being, physically abused in their home. If that was true, then it would constitute maltreatment. So that's going to get investigated. All right. Nationally, 4.2% of children are part of an investigation annually. In California, this number is 3.5%. So the question is, how many frequent flyers do we have, right? Like, how many kids do we have that that are unique, you know, visitors to the child welfare space, right? This doesn't tell us anything, by the way, about raw numbers exactly. There's a lot of different issues with these numbers and how we compare them to each other, and we're going to get into that in just a second. So 50% of the children investigated are found victims of maltreatment nationally, 14% in California. Okay, so that means that, you have 100 reports, 58 of them are investigated, right? And of those 58, 15% of those 58, 15% of those are found to be victims of maltreatment. All right, so we're having an apples, oranges, and lemons problem here. We have to be really, really careful with what we do with this data next. All right. So this is a different way of looking at the same thing that I just said. But here's the thing. 15% of those 58, about 9. 14% of those 50, about 7. Those are substantiations. But we don't know how many children those substantiations are representing. What? So 100 reports could be 100 kids one time, right? So you're getting 100 calls, and each one of those calls is about a different child. Or it can be 100 calls about one child. And if you think that that's a silly thing to say, for those of us who are old enough to remember, when Michael Jackson dangled his kid over the balcony, the edge of the balcony, you can bet that there were 100 calls on that kid, okay? Or a sibling set of 5, 20 times. Oh, wait, that's not quite right. Well, anyway, yes. So you get the idea, right? So the makeup of the numbers can be different, and there is no way to know from this apples and oranges sort of comparison what those all are. Okay. You with me so far? Okay. So we have more disparities here. So if you look around along the right edge of the slide, you'll see that we have 2 lines for each of these racial groups. And I just picked, Hispanic or Latino because they were the first on the list for my little example here. So shouldn't a 52% Latino population in the state mean that 50% and 52% of maltreated kids are Latino? Okay, shouldn't it mean that if the population in the state is 24% white, shouldn't 24% of the maltreated children also be white? Well, in an ideal world, yes, right? In an ideal world, those numbers would match up completely. And the gap in between those numbers are the disproportionate, question marks that we have sort of floating out there. Like, why are these numbers different? Why are there more Hispanic or Latino children represented in foster care than they are in the population? What is that about? So there's a traditional explanation for this, right? The traditional explanation is small amounts of social injustice factors and, leads to small difference in rates of maltreatment, right? So, um, if you are Hispanic or Latino, you're more likely to live in a neighborhood that has fewer resources, statistically speaking, than a white child. Okay, so the idea is that, there's some social injustice to that. There's fewer resources in your neighborhood. So, maybe one of those resources would have prevented you from coming into foster care. And so that's going to play itself out in the data, right? That's the idea. And then you add in this really big bias in reporting, right? And investigation and in case disposition. And the idea is that, mandated reporters or reporters in general are biased against, minority groups. Investigators are biased against minority groups. Judges who decide the case disposition biased against minority groups. And then you put all of this together and you end up with lower rates of maltreatment for advantaged groups and higher rates for disadvantaged groups. Makes sense, right? This is a theory that would make sense if you are, very devoted to, the concepts that we cover in this class. That structural bias matters, right? Social injustice factors matter, right? And we act in biased ways, both consciously and unconsciously, and we have to work hard to not act in biased ways. But because we're talking about institutional levels, institutions, that it's going to come out anyway, right? That it's going to come out in the statistics anyway. Okay, so that's the traditional explanation. But we have this growing body of evidence that large amounts of social injustice factors is really most of the difference in child maltreatment. So we've actually covered this already, right? When we were talking before about how the youth who emancipate from foster care, and 20 to 30% of them are homeless within a few years. That is not really about being in foster care. That's about all the other factors that have put them at disadvantage, that probably put them in foster care to start with. Being poor or having mental health challenges, or all of these social factors, these social injustice factors. Not really about the system of child welfare, and more about the system of society, right? And the different layers of Bronfenbrenner's model, right? And that is the majority of the lower rates for advantaged and higher rates for disadvantaged groups. And so, it's an interesting change in the mindset, but that evidence is pretty strong, and it continues to grow that this is the case. And I think that we cling to this original traditional explanation because I think the balance has changed. I do think that 50 years ago, and we're about to talk about an example of that, there was a huge bias in reporting, investigation, case disposition, all of that stuff, right? A huge bias. And, who knows how much of it was social injustice factors, like not ever small, I don't think. But for sure, that bias in reporting and investigation and case disposition was a much, much, much bigger deal than it is now. Okay, because we spend a lot of time talking about this. And so hopefully spending as much time talking about it as we do results in having, a smaller effect of it. So now we're looking at a similar slide, but now we're looking at the types of maltreatment. And now we got this whopping huge number where California has a neglect rate 15% higher than the rest of the country. So, that is huge. It's absolutely gigantic, right? So, but then when you go down a little further, the rates of physical abuse are very much lower, and the rates of sexual abuse also lower, not quite as much as physical abuse, but they're also lower. So, the neglect one has an explanation that I think we are all pretty comfortable with. California has a very high cost of living, and this has real implications for poverty related neglect. We have, the law is very clear that being homeless is not maltreatment, that being poor is not maltreatment. But if you don't have any food in the house, that is maltreatment, right? If you don't have housing, that's not maltreatment. But if you're sleeping on a park bench and you've been assaulted because you're sleeping outside, then you're very likely going to come into foster care, right? Because you're not safe. So you can see how poverty can lead to those disproportionately high levels of neglect in California. Also, there's some supervision stuff going on here, and supervision does fall under neglect. If you are working 2 full-time jobs and you are gone 80 hours a week, or, more realistically, you're gone, 100 hours a week or more because transportation and all of that, kind of by definition, your kids are not going to be supervised as much as they should be. So, you combine that with the very high cost of childcare, and you end up in a situation where you don't have the money to have your child properly looked after, but you can't go out and make more money because you have to look after your children. So, that's kind of a nasty loop. And if you're interested in that story, you should read Is There No Place for Us, which is one of the options for your social issue book, because basically the whole book is about that, but in Atlanta, not in California. So California might classify neglect differently than other states. As a matter of fact, it definitely does. But these are not apples to apples comparisons, right? So we have a broader definition of neglect than a lot of other places do. But also in some ways we have a more narrow definition of neglect. So, for example, in some places being homeless is considered neglect. So, like the definitions are different, and that can cause differences in the data. That same issue is also present in physical and sexual abuse, but also these might be addressed through different pathways other than child welfare, or identified at different rates. And those are 2 very different things, right? But, I think that there are lots of ways to intervene with physical abuse, in particular, that does not involve CPS. And that would pull the physical abuse number down, right? Also, lower rates in the data doesn't necessarily mean lower rates in the community, right? There can be characteristics of the reporting that bring the data into a lens that it's not accurate. But there's no way to know that, really. So there are others here, but the data doesn't tell us why. You know, like there's no magic bullet where we can be like, oh yeah, well this is clearly why California is disproportionate in this way and that way. And again, for neglect, it's a little simpler. The reasons can be more easily identified. But for abuse, for physical and sexual abuse, I'm not sure that that's as simple to identify as we would like it to be. All right. So, the takeaway here, okay? Statistics matter, but you really have to understand what you're measuring, right? So we can't know for sure always what all the statistics mean, and sometimes we have to make educated guesses, but we have to be clear when we're talking about data that we on what we do know and what we don't yet know, right? You can't take numbers and just run with them without context. Because if you look at all of these examples that we've just talked about for the last, hour and a half, you'll see, if you take any of them at face value, it tells you a very different story than the actual story that lays beneath them, right? And you didn't even these are the simple ones, right? You don't even have to dig particularly deeply on any of these to find the real story underneath them. But if like you go back one slide and you look at those, physical and sexual abuse numbers, you're like, uh-oh, what story does this data tell? I don't know. And I don't know either, so because we just haven't figured it out yet, right? So, don't run with numbers that don't have context, and be very careful about what you put out in the world as what is known and what is not known, because doing that has a way of perpetuating super harmful myths, not just in child welfare, but about a lot of things that the data seems to tell one story when you look at it in headline form, right? These are all headlines basically. But then once you start reading the article, turns out very different. All right, structure. So, best interest of the child and minimum sufficient level of care, you have to understand these concepts to really understand how the child welfare the child welfare system is structured. Okay, so the first concept, parens patriae, sorry. So, parens patriae is Latin for father of the people. And if you're kind of like, ew, then of that term, I understand. So the concept is that the state has the power to step in and assume the role of, parent. And this is not just about child protection. When we think about it in terms of child welfare and child protection, it's like, okay, the state is, acting as the parent should. But this concept exists in lots of other places. So, 5150s, that's the involuntary psychiatric hold. Those can be children, but they absolutely do not have to be. That's another example of when we use parens patriae. And, it makes people really uncomfortable to think of being put on involuntary hold under this principle that the government is, your parent, basically. And there's other instances of this as well. So, for example, vaccine mandates in schools also fall under parens patriae, because the idea is that it's a public health concern, and that the role of the government is to protect all the people, right? And so that's another example. There's lots of others, but those are kind of the most relevant to us right now. So anyway, when needed, the court in this role becomes the parent and makes decisions as a parent would do. So the principle is really embedded in every decision that the court makes. Um, the the idea is that, all the decisions, all the actions are made for a child with the same priority that a parent would hold for that child, and that the presumption is that it would be the best interest of the child. That's a big presumption, I feel, but that's the presumption. All right, so the other thing that's really important to understand is minimum sufficient level of care. Okay, so the definition of this is that the child's basic needs are met and they're not harmed physically, sexually, or emotionally. And boy, is that last one tricky. It's very hard to define that, and it's very hard to prove it when you try to define it. So there's reasons for this, right? The research is pretty clear that in general, a birth family that meets the minimum sufficient level of care standard um, leads to better outcomes for a child than a placement outside of their family exceeding it. Now, I don't want you to grab that and run too far with it. Okay, so on that's a population level outcome, right? The research is clear on that on a population level. So, it does not apply to any one specific example of child or family or whatever. What it's telling you is that when we look at the data in the aggregate, when we look at all of it all together, those children are better off, statistically speaking, in a birth family setting that is, marginal maybe, but does meet minimum sufficient level of care. They do better in terms of life outcomes than if they are removed from that setting and given a placement that exceeds the minimum sufficient level of care. Okay, lots of reasons for this. Okay, I will say that there's something very specific missing from this, which is, for a child that is put in a placement outside of their family that exceeds the minimum sufficient level of care. Okay, so what about the next placement and the placement after that and the placement after that? So that is one of the things, is that we're making an assumption that placement outside of the biological family is going to be a permanent one, and I don't think that is an assumption that we can ever make. All right, so why? Again, lots of reasons for this. Picture, we have a child. She's 6 years old. She's removed from mom's care. Mom is, living in a studio with, three other children in San Francisco. And, this one has been removed because failure to protect. She was sexually abused by mother's boyfriend. None of the other children were, so those children stay. This one goes. The question becomes, now what, right? So let's say that there's grandma, right? And grandma, grandma's not perfect. Grandma also has issues, but she's safe enough. She's not going to physically, sexually, or emotionally harm the child. She doesn't live in a great neighborhood. She doesn't have a lot of resources. The schools are not great. She doesn't have a lot of education herself, which statistically has a lot of impact on final education outcomes for the child. All of that stuff. So, it meets a minimum sufficient level of care, but it does not exceed it. Alternatively, the foster home that the child was initially put into in Danville, okay, like very high socioeconomic status on this family. They have, Buttons the pony living in the backyard, and Buttons is amazing, and this kid has her own pony, and she goes to the best schools, and she has, Disney vacations, and she's very well loved and cared for by these people. And on paper, right, it's obvious what choice should be made here, right? Um, but the problem is twofold. One, the 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 child has emotional attachments to their existing family, and when you sever those attachments or you strain them by putting the child into a placement that is physically far away, or not even necessarily physically far away, but definitely impacts the child's access to their birth family. Those attachments, those connections are damaged, and our attachment to our family is extremely important for our emotional health, for the health of the relationships that we build with other people. So there's damage to that for sure, but also, um, you know, if our example child, at 6 years old, is adopted into this family, and they're not genetically related to this child. She was cute and sweet and compliant when she was 6 years old, but now she's 16 years old, and maybe she didn't get all the mental health care that she needed. Maybe her trauma is still very much real for her, whatever it is. But she starts to act out, right? She starts to act out. She starts destroying things. She's really pushing the boundaries of the family. And let's say that she hurts the one of her adopted siblings, right? So, if she causes physical harm to a younger adopted sibling, a biological child of her adopted family, the chances that she ends up back in foster care 10 years after leaving it, are not zero. So, when you are placed in a biological family setting, your chances of that remaining permanent, being truly permanent, are better than if you are put into a non-related adoptive home. So, you know, the goal, regardless of how good the alternative looks on paper, is going to be to return that removed child as soon as the home is safe. If that is not possible, to return them to their biological family if possible. So in this example, grandma, right? Even if the foster home appears better or seems to provide more advantages, and Buttons the pony is the best pony in the world, that is always going to be the priority. Is that always what's going to happen? No, it isn't, right? Because in the reality of the situation, our kid could say, like, I will not go with grandma. Like, I do not want to do that. I do not want to be there. Or, there's concerns about grandma's health. Like, maybe grandma is 78 years old and has high blood pressure, and, this is a very active 6-year-old, and, like, everybody's concerned about the long-term viability of this placement. Well, then maybe this kid is better off getting adopted into this home, and us taking this risk that that the placement is not as permanent as we would hope, right? So those are very common types of scenarios for why it's really important to prioritize that biological tie. All right. So why is it minimum sufficient level of care, right? Like why is our bar so low? Like, okay, so they're not being harmed and their basic needs are met. Really? This is our bar? Well, so there's lots of reasons for this, and I'm not going to read through them all for you. You can see them there on the slide, but you know the one in the center is definitely the most important one, right? So minimum sufficient level of care, the agency, the child welfare agency, has to balance child safety and the rights of the parents, family autonomy, right? So there had to be some sort of standard that balanced these two things, right? So when we think about airplane safety, think about all the things that they do to make sure that your plane does not fall out of the sky, right? Like it's if objectively speaking, sort of ridiculous, right? Like all the stuff that is required. Every plane is checked after every single flight. It costs bajillions of dollars. Our priority is balanced so far towards safety that the autonomy of the airline to maintain the plane the way that they feel like maintaining it is very small, right? So in this case, the hope is that there's a good balance between child safety, and we're not removing children at the drop of a hat. um, because parents have a right to parent their children the way that they see fit, as long as it's not hurting the kids, right? So that's the priority, right? So minimum sufficient level of care is where we ended up. But how did we end up there? Well, um, this example is kind of how we ended up with this standard. So, um, prior to 1978, the philosophy of the time was very Eurocentric. The idea was that children needed one to two consistent adults, preferably two, um, as parent figures, and they needed shoes, and they needed formal education, and they needed a schoolhouse, and you know traditional Eurocentric things. But in Native cultures, these values weren't and are not necessarily prioritized. Right, this is not necessarily at the top of the list of these cultures. So, from the standpoint of, at this time, the largely white female social workers, and again, from this time point that we're looking at, these are moms and grandmas, and they have opinions about what parenting should look like, right? So they're kind of appalled by the conditions on reservations. There's these kids running around, and a lot of times in Native contexts, there isn't just like one to two consistent adults as a parent figure. It's more of a community, system of raising children. And, there's not necessarily formal school, and the schooling that they're getting is not, white social worker of 1977 approved, right? So the result of that was that before 1978, kind of an appallingly large number of Native American children were removed from their homes and placed intentionally in non-Indian families with the intent of essentially erasing the culture from which they came, right? That was the intention. So, you know, in an attempt to um, save native way of life, ICWA came around in 1978. So Congress passed the law, and the cornerstone of it was, we should not be removing children because there are cultural disagreements about how we should raise them. ICWA has a lot of protections for Native families and for Native children, and are around autonomy of the tribe, autonomy of the family, very specific rules about removals and interventions, and also what placements can be made, right? So ICWA requires that Indian children, and that's how they're defined in the Act, right? That's not really terminology we use now, but that's how they're defined in the Act. Indian children have a right to be in an Indian home if one is available. So they're going to look at their tribe first, and if they can't find a home in their own tribe, they're going to try to place the child with any Native family in any tribe, and only then, if no family is found, will they look at non-Indian placements. So here's some, kind of thought questions for you, and I think you can expect to see these on the quiz. But just think them through a little bit. Is there these two concepts travel together in child welfare, and they do have some tensions between them, and we just have to always keep in mind that this is the standard and why it is the standard. And if you want to know more, here's some things that you can look at. That podcast is particularly strong. That Crooked This Land podcast. Okay, the process. So the Welfare and Institutions Code, Section 300, gives us all of these different classifications of child maltreatment. Um, they are not, equally represented, right? The most common ones are A, B, C, D, E, J. Um, you know, G is something that we use when it's kind of not the fault of the parent, or it's not really related to why the child was removed in the first place. One of those two things. We'll use G if they're just like not there, right? Like so. I'm sure that we're seeing a lot of G counts right now for parents who have been deported. So you would see a lot of that. H is you only see that when a child has been freed for adoption. So since the parents no longer have rights to these children, there's no case against them because they don't have children anymore. So the petition becomes freed for adoption, and the initial allegations no longer exist on that case. Death of another child. Unfortunately, I have had a couple of cases where there was an F count. Um, it's not just that another child died, it was that another child died as a result of maltreatment. So, as one of those, 2,000 a year sort of situations. Cruelty, also uncommon, thank God. I have had one cruelty case over the years. And I still remember it, and I will probably remember it forever. Luckily, cruelty is very uncommon. So, for these other ones, there's, the percentages are a little bit misleading because in most petitions, there is more than one type of count. So often we see things together like neglect, so B, and J. So that's going to be a sibling count, right? So like it's happening to more than one child, right? So you're going to see those. So you see B a lot with J. You also see A or E with B. You see B in most petitions, I would say. But a lot of people ask why A and E are different. So physical abuse and severe physical abuse is under 5. So E only applies to children who are 5 and under, actually. So the distinction is this, that A is for children, it's a lesser count, really. It carries less weight because these, in theory, are larger children. They're bigger. They're more able to express themselves. They're more able to seek help if they need to seek help. They're not as helpless as the really little kids. So these are separate counts, and E is more serious because the assumption is that these children are not as able to protect themselves. Remember, this is court, so you can negotiate. Your lawyer and their lawyer can get together and negotiate some of this stuff, and often what you will see is that the petition starts with an E count and it gets negotiated down to an A count, which the court handles differently, more gently, I would say. Okay, so the report. So basically what happens is the hotline receives a call from a reporter, and for those of you who have been through mandated reporter training, you will recall that you are mandated only within the scope of your employment. That is true in California. In other states it works differently, but technically if you're a mandated reporter, you don't have to report things that you see that would constitute abuse or neglect if you are not on the clock. I personally have never met a mandated reporter who would just keep walking if they saw abuse or neglect happening in front of them and they weren't at work. But, technically speaking, you are not required if you're not at work. Okay, so the report is made, and CPS has responsibilities, and the reporter themselves has responsibilities. So CPS takes the report, and these are example terms because different counties will have different terms for this. They're all they all mean the same thing, and they're kind of interchangeable, but it's too hard to try to give you every iteration of all the terms. But the bottom line is you can have it not investigated at all, right? So that's like our truancy case from earlier in the lecture. It's not maltreatment. If it's true, it doesn't matter if it's true because it's not maltreatment. So it doesn't have anything to do with us. So it's evaluated out, is not investigated. Or it's going to be sent to emergency response for investigation. And it's more complicated than this. Again, I'm trying to put it down in a way that I can squash it onto one slide. But for the most part, they're going to fall into immediate, which is technically up to 24 hours, but ideally 2 in most counties, or 10-day. So what's going to be an immediate? So it's not always what you think it's going to be. So if the child is safe, it's not necessarily an immediate, right? Like even if it's severe. So for example, if a child is in the hospital for their injuries that they've received, and those injuries have already been documented by the doctor and all that stuff, it might not actually be an immediate because that child is safe. and that child is being cared for. Now, will it usually be an immediate? Yes, it usually will, but it doesn't have to be. When does it have to be? So, anytime that you make a call on a child and you allege that there is a marking on that child, and they're not in, receiving medical treatment, it's going to be an immediate because marks fade, right? And it's evidence. So, if a teacher calls at noon and says school lets out at 2:30, and I have a kid here who has a hand-shaped bruise on them, you're going to see a social worker before school lets out, ideally speaking anyway, because they're going to want to see that mark because it might not be there tomorrow, right? So that's one of the ways. So what makes up a 10-day is pretty much everything else. But, if an allegation is old or there's no evidence or, it's a one-off situation, lots and lots of things end up as 10 days. But, it's much more common for it to be a 10-day than for it to be an immediate. But, both of them are common. Okay, so the outcomes are of those investigations, right? So remember where we're starting from. So nationally, 58% are investigated, and in California, 50% are investigated. So the outcome of those investigations are going to be, unsubstantiated, or, it just, didn't happen, which it's hard to prove that something didn't happen, but that is an option. Inconclusive, we don't know, but it doesn't meet the standard of evidence. We can't take action on this. And substantiated. And again, if you will recall, nationally, substantiated is 15% of that 58% that got investigated. So if it's been investigated, 15% of those investigations are going to result in a substantiation. And nationally and in California, that's going to be 14%. So from the time of call, right? We're assuming base 100 calls. We're looking at 9 nationally substantiated and 7 in California based on 100 hotline calls. Okay, so the mandated reporter also has responsibilities here. You should not forget those responsibilities because they not fulfilling those next steps 98% of the time will not result in any sort of outcome, but that other 2% you're going to really regret that you did not do it. So the responsibility is that you complete the form. You're a mandated reporter. It can't be anonymous. That's your job. So there's a form to complete. And technically, it is your job to cross-report to law enforcement, animal welfare, adult protective services, whoever. That's technically your job. Okay, so some reminders for reporters, and there's a whole training, a million trainings really for mandated reporters, but here's 2 boxes for you. Okay, so you are obligated to report any suspicion of abuse or neglect. You do not need proof, nor should you be investigating, right? The people who investigate allegations are specially trained. Memory is a very finicky thing, and the idea behind the training that the investigators receive is that they are not influencing the memory of the people that they're speaking with. And it's really easy to mess with that. So, if you're interested in that, take my, Psych 1 class, because I do talk about that quite a bit. But it's not your job to dig around and get details. It is your job just to report whatever suspicion that you have and the basic information, right? Like you can't call CPS and be like, I think this kid was abused, but I didn't ask any questions. I don't know why. I just think the kid was abused. That's not going to work, right? There has to be some story here. Like this kid has a handprint on them. I didn't want to ask questions. That will get an investigation, right? So you don't need proof. You just need a suspicion, and it is not your job to decide, oh, does this rise to the level of something that should be investigated? That's not your job. There are people who have been trained for years to figure that out. All you have to do is meet your legal requirement to call any suspicion that you have into the hotline. Another thing that comes up a lot is supervisors, especially when workers are new to the field or are young or both. Your instinct is to get approval from your supervisor to make a call to CPS. It always feels like a really big deal to make a report to CPS, and it is. But it is not the job of your supervisor to approve or disapprove of your report. So often what ends up happening is that people will go to their supervisor and they will say, I have a suspicion of abuse for this child. And the supervisor will say, okay, but we've called that in many times before. Or they'll say, yeah, but we're working on it. Or they'll say, okay, I'll call it in. Or some variation on one of those, or any number of other things. But none of those are reasons for you not to call. It doesn't matter whether it's been called in, a dozen times, 24 times, 100 times. It doesn't matter. If you have a suspicion of abuse or neglect, unless you called it in, and none of the facts have changed, you should call it in again. That's your job. And why do we do that? Because they will add the facts that you have provided into the data that they already have. And maybe what ends up happening is like, yeah, it's been called in before. It's been called in 6 times before. But now you're calling in the 7th time and you have one piece of information that now makes this something that changes the outcome. So we're going to end up in a situation where if you listen to your supervisor and they said, oh, don't call, we've called that in 17 times. If you had listened to them, now this child is at real risk, right? So we need to be very aware that the responsibility is our responsibility. It is not the responsibility of the supervisor. And especially when you're new or young or both, I am very firm in my belief that for this particular thing, you should ask forgiveness and not permission, and go forward and get, and do, your due diligence. And from there, you can tell them, okay, I called CPS, right? And if they react badly to that, then they need to refresh themselves on their mandated reporter training. Okay, so let's say that the report has been substantiated, all right? So we've decided that maltreatment has occurred, or more to the point that the chances that maltreatment has occurred is more likely than that it has not occurred, okay? So this very tidy little progression, I wish it worked quite like this, just like this perfect sequence ABC thing. It does not work this way always, but for the purposes of our conversation, we cannot reasonably attack this unless we follow the diagram that we've been given. Okay. So, the child is removed from the home. Wait a minute. Is the child removed from the home? I don't know. Because you will recall that, there is a pretty big proportion of kids who are court dependent, who are not removed from the home and never have been. So maybe yes, but also maybe not. So, even just our first step, you're like, oh, I don't know. But in any case, the next step is that the petition has been filed, right? So these are the allegations. So let's say the child has been removed. It just makes it simpler. Within 48 hours of that child being taken into custody, the petition has to be filed with the court. And this is literally one page. And it says, according to, WIC section A, this child was hit with an open hand that left a mark on their skin. Okay, that's the allegation. And then after the allegation and the petition has been filed very quickly thereafter, I believe it's 24 hours, 48 hours, something like that, there is an initial hearing. This is the detention hearing. So the judge decides at this hearing the same day or the next court day, whether there's enough evidence to detain the children. So in California, we're pretty good at this. I mean, I suppose it must differ by county, but in all the counties that I've worked in, we're pretty good at this. Rarely does it happen that there is not enough evidence to detain. Rarely does it happen that the children are returned to the care of the parents at the detention hearing because there isn't enough evidence. Now, they can be returned if there is no longer a threat, right? So, if the thing that brought them into care is no longer, present as a risk, for example, the offending parent has been arrested, and it doesn't look like they're coming back anytime soon. Depressingly, the best example that I have for this is a child who was abused in the process of a murder, and the perpetrator parent has been arrested, and they're not coming back anytime soon. So those dependency proceedings might end right there. So it that's an extreme example, but it certainly happens that they can be returned because there is no longer a threat, or they can be returned because there isn't enough evidence. So the next hearing, you have the social worker has 2 weeks, basically, to investigate. And this is usually done still within the emergency response unit. So this is still the social worker who did the initial who went out initially to take a look, talk to the parents, all of that stuff. So their job is to investigate. They're supposed to talk to the children, the parents, whoever it is that they need to talk to, and try and figure out what actually happened, and then sit down, write a report for the court, and the judge then decides, it's a higher level of evidence, right? Than evidence to detain. So, at the detention hearing, the level of evidence required is fairly low, right? For the most part, it's like, are we worried that this might have happened, right? At the jurisdiction hearing, though, there's a higher level of requirement for evidence here. And if you talk to, 5 witnesses and the parents and all the other siblings and everybody says it didn't happen, you're not going to make it past the jurisdiction hearing as a case, right? But if you talk to all those people and they all say, yep, watched it happen, definitely happened, then jurisdiction is not going to be hard to get. Okay, so that's just the hearing that occurs that lets us establish that the court does have a right to take that parents patriae role. The disposition hearing often happens at the same time as the jurisdiction hearing. So, you know, if you're reasonably sure that you're going to get jurisdiction, you can put these hearings on the same day, right? So, you know, if the fact pattern is not contested, and that happens a lot actually, is that, you know, the parents will not try to pick apart the allegations and be like, no, that didn't happen, none of this happened at all. You know, if we're not contesting the fact pattern, then this isn't much of a hearing, right? So now we're just sort of jumping to disposition, which is, what are we doing now? Right? What's the plan? These kids are now in foster care. That clock starts counting from the jurisdiction hearing, and you know, now what? And the idea is, you know, there's a reunification plan, or sometimes we go directly to adoption or whatever it is, but the plan begins at this point, right? So let's say that it's a reunification plan, right? So we've had juris and disposition on the same day, juris dispo, and come out of that hearing with jurisdiction and a plan of reunification. Okay, so at the 6 month review, so 6 months goes by where the parents have time to work on the plan that was given to them, right? So, you know, our plan is reunification. Well, the parents have a list of things that they have to do to get the kids back in their care. So, you know, they have to visit this many times a week, and they have to look for work, and they have to look for housing, and they have to, you know, do parenting classes. These are all very common things, you know, drug treatment. All of this is very common. And at the 6 month review, the question is going to be, have you satisfied the requirements of your plan? And you know, sometimes the answer is very clear. Parent has not engaged with the plan. We haven't seen the parent since day one. Like, no parent, you know, in which case we're probably done at this point. Like, if the parent has completely disappeared, we're probably, especially with a little kid, going on to permanency. But if they're kind of partially engaged but not fully engaged, and the child is over 6, then they're probably going to get another 6 months to kind of get it together. If the kid is little, if they're under 6, they're much more strict. As you know, you have to show that you're really doing the thing, right? In order to get more time at 6 months, because you know the requirement basically is you need to get it done within 6 months with a little kid, and that is all about attachment, right? Like, we don't want these kids to be floating without a primary attachment figure for very long. It's just not emotionally healthy for them. So that 6 month review hearing is critical for the little kids. It's not that it isn't important for the big kids, but for the little kids, it is absolutely critical to what happens next. So, backwards. So, permanency hearing is where, you know, something, it is clear what we're doing now. So if the parents have satisfied the requirements of the plan, then the permanency hearing, the recommendation will be family maintenance. So let's send these kids home with their parents, but still under the supervision of the court. Everything is the same, except they're no longer in foster care. They're in the care of their parents, but they're still getting the social worker visits. They still have all the, you know, court supervision, all of that stuff. Some of the financials are different. Obviously, the parents are not being paid to keep their own children, but like the legal part of it is all more or less the same. If the permanency hearing rolls around and reunification is terminated, so the parents have not engaged at all or enough, or you know, they've gotten all the time that the judge can give them in a reasonable way, and it just has not happened, The recommendation of permanency is going to be some sort of permanent plan. It's going to be adoption or guardianship, or something that is permanent for that child. Um, every so often, you get long-term foster care for those older kids, but really we discourage that. In the olden days, long-term foster care was a fairly common thing to come up with at the permanency hearing, but for the most part now it's not as common. All right. The 2-6 is the hearing where the parental rights are terminated. That will only happen if the plan is adoption. So, this 120 days, right? So that's 4 months, right? From the permanency hearing, right? If reunification has been terminated, why 4 months? Well, we're gonna give parents the opportunity to object. We're gonna give them an opportunity to argue about the whole thing and to say, I didn't get what I needed. I didn't get the services that I needed. I want to appeal. And so there's a certain amount of time that they have in which to do this. And in theory, at least, the 2-6 will be held, 4 months after the permanency hearing. Almost never does that happen. There's a bunch of reasons why not, but not the last on the list is the child needs to be in a placement where everybody's pretty confident that they're going to be adopted. If they're not in an adoptive placement, if they're not in the placement with the parents who want to adopt them and are appropriate for adopting them, then there will not be a 2-6 until they are. They will just continue to have review hearings, until the end of time, basically. Until that happens, until there is, an identification of that adoptive family and a placement into that adoptive family home. And after that placement has been in place for a while and everybody feels very confident that this will actually go forward, then they're going to do the 2-6, right? And after the 2-6, some time goes by, and then the adoption is finalized. So now those kids are done, right? But if your plan was not adoption, then you end up going on to post permanency review hearings. So let's say that your plan is long-term foster care. If your plan is long-term foster care, then you're going to have a hearing every 6 months, just like you did when you were in reunification, except your parents aren't there, because they're not part of the plan anymore. So, you're going to go to your hearing and talk to the judge about, school and all of that stuff. And, that goes on until the end of the case. Guardianship is complicated. For the most part, there are not hearings once a child has been placed on guardianship. I've seen exceptions to that, but that's too deep into the legal weeds for me to truly be able to explain it to you, because I don't fully understand it myself. But guardianship, for the most part, does not involve continuing dependency, right? The dependency case is closed at that point. Okay, there is another path. So if your allegation has been substantiated, but there are reasons to think that there's no need to throw the book at you, right? That there's no need to go the whole judge and lawyer route, then you might be a candidate for voluntary services. So this comes into place when there is a substantiated allegation, but there's a lot of social support that can mitigate risk. or there's extenuating circumstances or something like that, or the perpetrating parent is gone for a while or for forever, then sometimes voluntary services will be the solution. Also, if the parent is like very gung ho about being involved with social services, like really, really wants the help, if you're listening to this and you're like, is that a thing? It absolutely is a thing. Um, you know, not not everybody who becomes involved with child welfare is devastated to be involved with child welfare because if they had positive experiences with the system previously, or they're aware of positive experiences with it, often people will welcome the intervention as support for what they need. And obviously this makes the work from the perspective of the social worker much easier, right? Because you have somebody who's willing and eager to work with you, and you don't have to kind of massage the situation to make it so that it's kind of easier for you to work as a team. They're already motivated to work as a team. In my experience, when I have had somebody who is that gung ho to be involved in services, it is either somebody who has a drug problem and they are absolutely ready to no longer have a drug problem, and they really just want the support not to have the drug problem. Then that's going to be the path. Um, the other reason would be that they really have a whole bunch of people, right? They have a mom around, and they live with three generations of family, and all of this stuff. So there's a lot of that, right? There's another one too. Is if they themselves were involved in child welfare, and it was a positive experience, when they were children, they can often be excited for voluntary services and be welcoming of that. Not very common actually, but it does happen, right? So the safety plan that comes into play with the voluntary services pretty much always includes a court as a last resort. So basically, like, this is your plan, voluntary services, there's no court, there's no lawyers, but you have a social worker, and, often there's a contractor who's providing services. So like a social worker who works for a private agency or whatever, who's providing services to this family. But the safety plan for them is going to basically say, like, if you don't engage, if you're not engaging like you said that you would, if it's not going well, if you fail a drug test, whatever it is, right? The safety plan is going to say, like, then we will consider this voluntary service thing to have failed, and you will be, a petition will be filed, and you will go to court. So I guess my question would be, and this is for you to think about. This is not really for me to answer while I'm talking to myself, but you know, is it voluntary if your alternative is court involvement? If your options are engage in these services or go to court, is it voluntary? I don't know. Like, that's something for you to think through. Okay. So where we are and where we're headed. So over the last decades, child welfare in general, but especially in California, has really pursued social justice priorities by putting forward evidence based practice and, policies and procedures over traditional kind of crusty institutional beliefs that really built upon bias and structural racism and perpetuated the same, right? So, um, California has until very recently been kind of at the forefront of this prioritization of evidence based policies. Um, so it kind of change comes in two flavors: um, legislation and lawsuits. So legislation is a law has been passed through the legislature and the governor has signed it, or sometimes it's a federal law and the president has signed it, either way. And, we've had a lot of reforms that have come through legislation, but kind of by definition, those are very slow, right? Legislation in general is kind of a slow process. But we've made a lot of strides in a lot of these areas through legislation. But lawsuits are fast, or at least they can be fast. So, maybe the lawsuit itself didn't work its way through the courts particularly quickly, but once a ruling is made, um, it is not infrequent that whatever the ruling says has to happen goes into effect immediately, right? So, some of the lawsuits that have made really big differences focus on all of these things, but mental health services, KDA, right? The Katie KATIE A case, the KDA case, um, was instrumental. That was about 2009 or 10 or something like that, was really instrumental in how mental health services are approached for foster youth. Um, Basically, the bottom line is no longer do foster youth have to just sort of wait and hope that their referral for mental health services will go through or will be handled in a timely manner. That is now a requirement. That foster youth are provided with mental health services in a timely way. And as somebody who worked in child welfare before that ruling and after, I can tell you it made a big difference. And not only did it make a big difference for the youth, but it also made a big difference for us as social workers, because a lot of the therapists are social workers. So it created an increased demand for social workers, right? So the licensed clinical social workers who act as mental health practitioners for these youth. So that's just one example of the how lawsuits have affected the landscape of child welfare. So, just a note, if this topic interests you, we have the benefit of having in our very backyard one of the preeminent scholars in child welfare. Jill Barrick is a professor in the School of Social Welfare at Berkeley, and she just happens to be very involved with the undergraduates there. And that's not very common for a prolific researcher. She has a lot of publications. She continues to publish at what I consider to be sort of a dizzying rate. And for the most part, folks like that tend not to be particularly involved with undergraduates, but she is. So if child welfare is the direction that you want your career to go, and you're willing to work hard enough to succeed at Berkeley, you can hardly do better than to go to Berkeley and introduce yourself to Dr. Barrick and try to get into one of her classes. It's basically learning how to play basketball from Michael Jordan, right? And if you're like, oh, I could never get into Berkeley, probably you can. They accept a third of transfer applicants from California community colleges, and students are usually pretty surprised when I say that to them. Yeah, I mean, you have to have good grades and you have to demonstrate that, you're a hard worker, but, it's not like trying to get into Berkeley cold out of high school. That's much harder, especially if you're not from California. But, you know, it's an excellent school if you are interested in social work, either, from an undergraduate perspective or a graduate perspective. Um, it behooves you to aim yourself at Berkeley. Jill Barrick is not the only researcher there who focuses on child welfare with a strong name in the field. Um, and it's obviously it's local, right? Like you don't have to travel very far. So um, yeah, this is a amazing resource for you that we just happen to have. Okay, so if you have any questions or you just want to chat about this, because obviously I can talk about it for a very long time, let me know, and I'm just happy to chat at any time.